Welcome back. You're watching Startup Central with me, Nayantara Rai, working from home. Ladies and gentlemen, keep writing into us. Tell us what you think of the show, how we should be doing things differently. Our email address, suc@etnow.tv. You can also reach out to me directly on Twitter. Well, we just finished a conversation with Amazon, but let's talk a little more about e-commerce. The reason for that is that the union government has put out draft rules for e-commerce companies to protect consumers. There's a lot of changes expected for the e-commerce giants as well as the smaller players. Remember, the government is already dabbling with the idea of having a regulator for online shopping, but it's looking like online shopping in for a big makeover so that consumers have more rights. So what the government, for example, has suggested in the proposal it has mooted is that there must be an adequate grievance redressal mechanism which must be highlighted by every e-commerce entity. But it doesn't stop there. Every seller's grievance officer must also be published, as well as the contact information. If the consumer wants to reach out to the seller and does so in writing, it might become incumbent on the e-commerce platform to connect the consumer with the seller. As far as the seller goes, a whole host of other rules that might be in place. Some have been talked about before. For example, a seller cannot masquerade as a consumer and indulge in reviews. So let's talk about the big makeover in the works for e-commerce companies. And to talk to me about that is the partner at L&L law firm, Vaibhav Kakkar. Hi, Vaibhav. Thanks for joining us here on Startup Central. Hope you and the entire L&L team is safe and healthy during this pandemic. So draft rules for e-commerce companies with the idea of protecting consumers. Let's first talk about grievance redressal mechanism that is being floated. What can possibly be an adequate grievance redressal mechanism? What the government has said is there must be a grievance officer, a complaint must be acknowledged within 48 hours, and all contact information must be enlisted. A ticket number must be generated for a complaint as well. Is this good enough, and isn't this already done by most, at least by the bigger players?
Hi, Nayantara. First of all, thank you for having me over, and hope all of you are staying safe as well. Yes, I think to answer your specific question, many of the prominent e-commerce companies are following those standards. But I think the idea is to now, from a lawmaker's standpoint, come up with uniform set of rules that are applicable for all kinds of e-commerce companies out there, some not so big, some not as well developed and organized. And the idea is to have certain uniform set of rules applicable to all of them. And the grievance redressal mechanism is one classic example of that, where they have prescribed a particular framework. I do, however, wonder that I think somewhere they seem to have still gone a little overboard, where they've not only prescribed a grievance redressal mechanism for the e-commerce company, but even for each individual seller on the platform is required to have their own respective grievance redressal officers. In the whole context of marketplaces where sellers are meant to be far more democratized and they will be individual sellers, I wonder if all the sellers will have the necessary wherewithal to have dedicated grievance redressal mechanisms and so on and so forth. But I would say still it's a step in the right direction, and these rules are far more relaxed draft rules than what we had seen the last time around in I think the last part of 2019.
No, that's a very interesting point to make up, because the marketplace is supposed to have democratized, right? That's one of the things that we celebrate about e-commerce. So let me try and highlight it with an example. Supposing I'm a homegrown, I work at home, I make pickles. Let's say I make mango pickles and I sell it, let's say, on Amazon or Flipkart. How am I supposed to have a grievance officer? Or in that case, I am the grievance officer. What can be a likely solution for this? Everyone is not a corporation. Everyone doesn't work for a large seller. There are, literally housewives that are now selling, for example, on Amazon and Flipkart.
No, I think you make a fair point. I think they have gone a little overboard. I think with the objective of taking into account the interest of the consumers, they have provided for two layers of protection, one at the e-commerce entity level and second at the level of the sellers. If the sellers are going to be individual sellers who may not have the necessary wherewithal, it'll be a challenge. I would imagine that eventually, basis feedback and comments, and I must state one thing and congratulate the ministry. They've been very, very forthcoming, positive. They've been receptive to changes. And I think this is one of those points which, if explained properly, I think can be easily addressed. As long as the e-commerce entity on which the sellers are listed has necessary contractual arrangements with the sellers that if there is a complaint which the e-commerce entity receives, they will, back to back send that complaint to the seller to look into, and seller will do whatever they can to resolve it in a time bound manner. That sort of a fix will take care of consumers' issues, but at the same time not overburden both the seller and the e-commerce entity.
Yeah, right. And that now something else that this draft rule talks about is that an e-commerce entity must highlight if it is giving any preferential treatment to a seller. Now I can understand that, for let's say electronics, are you giving a preferential treatment to one particular brand of a smartphone over the other? You must inform that to the consumers. And in fact, that is something, for example, specifically in this case is already being looked at by the Competition Commission of India. But once again, let me, come down the value chain. What if I'm a mango pickle seller? What if I sell, let's say, haldi face packs? Things like that. What can be a preferential treatment and how can it be highlighted?
To be honest, I think this particular rule is actually meant to protect those individual sellers, the kinds that you've just mentioned. What this rule is essentially aimed at is this particular rule seems to have been bases the CCI paper that had come out on the current status of the e-commerce market, and they had made some damning observations around platform neutrality, where they'd observed that a lot of e-commerce marketplaces tend to give preferential treatment to their own private labels, which of course is a no-no if it is FDI funded e-commerce marketplace because of the FDI rules. Alternatively, sometimes there are preferred sellers on the marketplace. So individual sellers of the kind that you just mentioned sometimes often end up getting a raw deal. So this is actually meant to give a level playing level playing field for all the sellers, where nobody's should be giving any special treatment. Now, somewhere I do personally believe, Nayantara, that you are taking away the innovation that every e-commerce entity can bring to try and attract the consumer on the marketplace. Ultimately, let's not forget that these are rules that are being meant to protect the interests of the consumers. And so if there are special treatments that are being given to certain sellers, as long as you make disclosures about it, as long as they're out there, and ultimately the consumer is benefiting, I don't believe that it's necessarily a bad thing. But of course, I think somewhere the regulator is trying to also play the monitor to observe that there is good equitable treatment, which I do believe is somewhat excessive interruption and interference in business practices of corporates. But I think that's where they're coming from, and which is why they're going as far as saying that there ought not to be any preferential treatment to any of the sellers in the marketplace.
Minimum government, maximum governance. We all love that phrase, right? But, e-commerce in that sense was not regulated at all. I'm going to make this my final question, Vaibhav. The draft guidelines also talk about the fact that an e-commerce entity cannot indulge in price manipulation. So while it calls for things which are very pro-consumer, for example, no cancellation charges unless the e-commerce company also bears with it, the fact that a consumer can choose the mode of payment as far as repayments go, it says there can be no price manipulation, so the e-commerce company can't make a profit. What does that exactly mean? I'm not understanding, because all this time we've said that an e-commerce company, as per the new guidelines, is a marketplace. So it connects buyers and sellers. So are we now supposed to believe, is that what has happened, that e-commerce entities in the middle have been profiteering?
I think you raise a very valid question. That particular rule that you're referring to is somewhat drafted ambiguously. I think it is aimed at essentially ensuring that the e-commerce entity, along with the seller, if it is a marketplace entity, ought not to come up with any sort of framework within which the consumer ends up being, being duped by coming up with some sort of, for instance, hidden charges. Sometimes you end up offering discounts, but ultimately it gets loaded onto the price of the good eventually. So you are given the impression that there is a discount, there is a cashback, but it's actually not the case. So I think it's essentially aimed at ensuring that there is no deceptive, unfair trade practice being played out on the consumer's interest. It's something which is there also in the Parent Act. I think it's been more specifically elaborated in the context of consumer protection law. I think two very quick observations. I think on the same rule that you're referring to, it even goes on to say that there should be no advantage taken to offer pricing at a time which really prejudices the interest of the consumer. I find it fascinating that it's been brought out in the backdrop of COVID. I can totally imagine how these rules will almost get invoked, similar to the ESMA, essentials goods and essential services. For instance, the price of hand sanitizers or mask, etc., that you can't be seen as over profiteering. I think somewhere I believe that that overhang has come into these rules, and I do believe that they tend to be a little more interfering in how businesses should be left for
Right.
companies to operate freely. I think one very quick point, Nayantara, I know you're running out of time, is the fact that what these rules also interestingly also bring out very clearly is that foreign e-commerce companies, a lot of consumers we know end up buying for price arbitrage from Chinese online e-commerce companies and so on and so forth. And what they're saying is that if online e-commerce companies are being operated from abroad, but they are in a systematic manner offering goods and services to consumers in India. For instance, a lot of individuals in India do end up resorting to Alibaba and Alipay and those sorts of websites. They are saying that they will also be brought within the fold of the Indian regulatory purview, and they will also be required to follow these standards. I think that is pretty significant, and it will also nudge a lot of e-commerce companies which are based out of overseas, who are really not operating in the country yet are doing a lot of business, to I think start following certain basic equitable and hygiene principles. I think that's a very remarkable and a significant point, which will have a disruption in the market.
Okay, so they will have no choice but to maybe open offices over here to actually work here and follow all the laws over here. Maybe even start paying taxes here. Vaibhav, it's always a pleasure talking to you. That's L&L's partner, Vaibhav Kakkar, talking to you about how online shopping is in for a big makeover. That's how shopping online can change in the short term.